Lordship, this item number hearing, item number 4. Lordship. So in this case, you will say I am having this record. So when I inquired about this postal matters, you will see, then I've seen this here pin code this and two receipt is different numbers. Then I was trying to locate this one. So it will take some time because this is not the unit. So is there any other unit in this pin code was there or any letter was given? Just to find out some time will be required.
I think the last order is very clear.
So you see, in this matters, so this out of this, now it becomes difficult for me to find out. You see. So they are saying this.
So we'll do one thing.
So in this
we'll
situation,
take it that you have not been able to ascertain.
So then this matter will be better to file the affidavit by the unit. You see.
Why? What affidavit you want to file?
Because this postal receipt and regarding this letter, it is not available in the office. So better to file one affidavit in this matter.
You mean to say that you have not received?
So you will see they are not located in, and one letter is given, it is not located. So even when pin code is given, one is 900002 and another is 93012. So this completely different, not the same unit. So whether any unit in this location, what is there on pertaining to this petitioner, this has to be ascertained then. So that's why I tell the department just give some reply on it. So in this matters, I think it will be better to buy affidavit because contents of the letters are not available. They are not having the worst letter they are given, and in the department proceeding it is not taken into consideration. This is the correct position.
Hearing is also completed, Your Lordship.
Hearing completed, Your Lordship. This file, other than this, all the record is there.
Hearing is completed, but they have short time to. I mean, in fact, this court has inquired as to the status or whether as to the position of the petition or letters that were filed by you. The sad thing is that you have not kept a copy.
You didn't retain a copy.
So that is partly your fault. And the other thing is that if your assertion is true that you have sent such letters, it should have been in their their file. But if they could not locate such letter, then
at this stage, Your Lordship, they are bringing this plea. At this stage, Your Lordship, this could have been for so long. It has been pending for steps. Nothing has been done all this while, Your Lordship. Now, at the end of the day, they have come up with this plea, Your Lordship.
But it would be to your, it will be to your advantage if they could locate those letters, you see, because that would prove that you have indeed sent such letter. Otherwise, now they say that no, it has not been, except for those postal receipts. Postal receipts are postal receipts. The post office would not keep a copy of the body of the item. They would just indicate that it has passed through the post office, and that's all. So I'll give you 2 weeks time. Last. Mr. Adamna, Leonard.
The record will give together or this?
Not necessarily. You keep the record and file that affidavit. Mr. Adamna, Leonard, CGC has submitted that the department has not yet been able to locate or find out the letters said to have been sent by the petitioner, whereby her overstay of leave has been explained, and even on the basis of the said postal receipt filed by the petitioner, produced by the petitioner, the related document or letter have not yet been located. It is therefore prayed that some more time may be allowed for the department to make an effort to locate such letters and to file an affidavit in this regard within the next date fixed. The counsel for the petitioner has submitted that this matter has already been heard, and at this point of time, coming up with this plea would not be permissible for the respondents to do so. However, keeping in mind the query made by this court, which issue would have a bearing on the merits of this case, this court would grant further time to the respondent to do so, to take necessary steps. As prayed for, this is matter of 2 weeks.
So let it be reflected
But
that
you-
positively they may bring on the record, Your Lordship.
You do that.
Obliged, Your Lordship.
May I please, Your Lordship, I beg to mention item number 3, Your Lordship. As Mr. S.J. is on sanction leave, Your Lordship, that this matter be taken after 2 weeks.
2017 matter, I don't think we'll. You are there in this case?
No, Your Lordship. I'm appearing on behalf of the counsel for the petitioner.
Who is the counsel?
Mr. S.D.
On prayer made by the petitioner, this is matter 1 week and no more time.
Your Lordship, similar prayer for item number 6, Your Lordship.
Lordship, item number 6, I'm the petitioner, Lordship.
Petitioner.
Yes, protest. Maybe short time may be given because this is the item from 2018. So from my side, I was ready, but since they have taken section leave, maybe short time, Lordship.
On prayer, you responded?
Respondent 1 to 3, Your Lordship.
On prayer made by respondent 1, 2 and 3, not objected to by petitioner. This is matter after 2 weeks.
Much obliged, Your Lordship.
Lordship, in item number 21, I am for the private respondent, Lordship. Lordship, I like to file one small affidavit, bring on record certain factual aspects, Lordship. Previous occasion, I just entered my appearance, Lordship. This is not a counter affidavit, my lord.
This is that sexual harassment at workplace.
Lordship.
Yes, that is the allegation put against me,
Lordship,
against them.
at the meantime, I also may be allowed to just file one additional affidavit, one document to bring on record. There is a certain after filing of the petition, I have brought there is a complaint against even the IO also. The IO has abused the power he was supporting in favor of the private respondent. So they have make a complaint to the DGP and the SP, concerned officer, to take action against the IO for abuse of process. That document was there, Your Lordship. So I maybe this to bring on record, it will be good to just maybe allowed to file an additional affidavit. At the meantime, if learned friend is moreover he's taking time for filing sort of affidavit. At the meantime, I'll file and supply the copy out to all the respective parties, Lordship.
On prayer made by the by the parties, this is matter after 2 weeks.
3 weeks, Lordship.
3 weeks.
Maybe indicate that we will be filing a respective.
This is a time for mentioning, not if you want to
Lordship,
make a prayer.
let it,
if you want to make a
come,
submission, let the matter
Lordship,
come.
that's why. Let it come in the order. I will make a prayer, Lordship.
Fine. Top. Yeah.
Shiv, I beg to mention item number 2, my lord. Mr. Paul is not here today, my lord, so I'm praying if this matter can be listed next week, my lord.
think the parties have agreed that this matter will be taken up today.
My lord. My lord, there's some difficulty, my lord, today. Let it be come up next week, my lord.
I think most of the time it's the petitioner who has sought for. You are the one who's pursuing the matter. Now you are the one who's delaying the matter. What do we do? What is the case about?
Yeah, my lord, we have challenged the order passed by the Meghalaya Revenue Board, my lord.
Or Revenue Board? Is it with regard to the
2015 minutes, we are suffering a stay order.
Oh, is this
From 2015 minutes. And Lordships will recall on the last date, Mr. Paul had submitted the briefing council is indisposed.
Yes, my lord. I was
Today, briefing council is present, but arguing council is absent.
okay.
We are equally exhausted as respondents. How do we pursue this matter? From 2015, we are suffering a stay order.
So then
My lord, we fix it next week. We'll try to.
we'll release the stay.
My lord.
That could be a conditional orders, if I may pray, that in case on the next date they're not available, then the stay order will be vacated.
My lord, next
It
day.
should be more often than not. Stay order should not travel beyond 6 months.
Lordships, that Asian resurfacing was made very clear. Can't be more than 6 months. So here it's gone beyond 6 months, beyond 6 years now.
A week's time, my lord.
The petitioner has once again prayed for accommodation in this matter on ground of personal difficulty of the Learned Conducting Council. Time and again, this court has indicated that this is a long pending matter and it would be fit and proper for all concerned that the same is disposed of expeditiously and in accordance with law. Mr. S. Sen, you are appearing for?
Private respondent notes.
Appearing for respondent number?
That's number 2, no? 2 Lordships.
Who has submitted that at the initial stage of this matter, of this case, a stay was granted by this court on the operation of the impugn. Is there an impugn order or
impugn order passed by the Board of Revenue?
Impugn order passed by the Board of Revenue. Such stay order has continued till date, which would be detrimental to the case of the petitioner of the respondents. Be that as it may, this court on the prayer of the petitioner is inclined to allow the same. However, it is made clear that if the matter is not taken up on the next date, the stay granted will be vacated. As prayed for.
Yes, may I just pray for a date, Malots, on the 10th of next month, if it is convenient to the court?
Yes, miss.
Then let it come up after 2 weeks, my lord.
So which is why I'm praying 10th of next month. That will give them sufficient time.
10th, okay?
My lord, fixed date will be with. I have to consult with Mr. Paul also, my lord, whether he will be available or not. Then
No, once we give a fixed date, then you can accommodate, you can arrange.
It's convenient, my lord.
You can arrange a court. As prayed for, this is matter on 10th.
That's highly obliged. Grateful, Malots. Sanjay Das?
May it please your lordship, I beg to mention item number 10. Your lordship, the conducting counsel, Mr. P. Nongri, is out of station. We pray that this matter may be listed after 2 weeks.
On prayer made by petitioner, this is matter to 2 weeks.
Much obliged.
May it please your lordship, I beg to mention on item number 12. Item 12, your lordship.
You're for?
Respondent 1 and 2, Your Lordship.
Any objection?
No objections, Your Lordship.
On pre-made by the respondent 1 and 2, not objected to by petitioner. This is matter up to 2 weeks.
I oblige, Your Lordship.
Your Lordship, I beg to mention item number 19. I should read the personal difficulty of your arguing counsel. Let this matter come up after 3 weeks.
You're for?
For the respondent, Your Lordship.
State respondent.
No, Lordship.
No, Your Lordship. It's private respondent.
Private respondent.
And you are for?
I am the petitioner, Your Lordship.
Any objection?
No, Your Lordship.
On pre-made by the respondent number?
2.
2.
No, Your Lordship. Here in the sole respondent, Your Lordship.
Sole respondent?
Yes. 19.
The state is a party here.
No, Your Lordship.
You're mentioning item number?
19.
19? Sorry. I thought 9. On pre-made by the respondent, not objected to by petitioner. This is matter of the 3 weeks.
I oblige, Your Lordship.
Please, Your Lordship. Your Lordship, I beg to mention item number 16. Item number 16, Your Lordship. I seek for some accommodation for today, Your Lordship, and pray that this matter may come up after 2 weeks.
On pre-made by the petitioner, this is matter of the 3 weeks.
Highly obliged.
Please, Your Lordship. I beg to mention item number 9, Your Lordship. Item number 9.
You're for?
Petitioner, Your Lordship.
Petitioner.
For the state respondents, we can have this next week.
What is this matter for?
This is a proceedings under the Drugs and Cosmetics Act. They are challenging it on the ground that the court did not have any jurisdiction to take up this case.
On pre-made by the petitioner, not objected to by respondent. This is matter to 2 weeks.
I'll leave it.
Similar prior for item 11, Your Lordship.
Lord, I appear on behalf of the petitioner in this case.
Oh, petitioner. You're for respondent?
Yes, Your Lordship. Respondent.
I am for the petitioner.
Yes, Mr. Dubey. Any objection?
No, my lord.
On pre-made by the respondent, not objected to by petitioner. List this matter after 2 weeks. 2 weeks.
Deeply. Well,
Supplementary clause list, item number 1.
My lord, this is application under section 482, my lord. There are private parties are here, my lord. The victim and the complainant. Well, let the notice may be issued to this for the motion, my lord.
May it please, Lordship, this is a case of 307 where they have sought for compromise. It cannot be, Your Lordship, because in view of the bar of section 320 of the CRPC, Your Lordship.
It can, my lord.
Cannot be, Your
482, my lord, inherent power. There are certain judgments, my lord.
Lordship, I have a certain judgment of the Supreme Court also, Your Lordship.
We'll hear the parties.
My lord, my lord.
Otherwise, notice to the private respondent is not required, Your Lordship.
Why?
It's not required, Your Lordship. This is
Yes, I read them as parties.
This is totally a question of law, whether it can be compoundable or not, Your Lordship.
It is not a compoundable, therefore we have invoked section 482.
It's not a compoundable. That is.
It is not compoundable, Your Lordship.
So, whether the court can compound it.
My lord.
Narendra Singh is there in other cases, but anyway, we'll see.
My lord. All right.
Petitioner appearing to Mr. P. Yogin, legal counsel, has submitted that at this stage, notice may be allowed to be issued upon respondent 3 and 4. The respondent number 1 and 2 being duly represented by Mr. Indishula in AAG, and as such, no notice is required upon the said respondent. On preamble, the same is allowed. Let notice be issued upon respondent 3 and 4 respectively, returnable within 2 weeks.
2 weeks. Obliged. Sure.
Item number 2.
Are you dreaming or are you sleeping?
My lord, I thought that number is not yet come, my lord. So,
What do we do? Should we take it off at the end of the board, or should we start right now? Give your other colleagues a chance to.
it depends on my friend and my other 3 colleagues how long they will take, my lord.
Huh?
You can pick up after
At the end of the board also.
end of the board.
Yes, yes, we can do that. We can do that.
Lady Constance, item number 1.
Status file is available.
Mr. You are appearing for? You are for? No, you are appearing for?
Respondent number 6, 7, 8, 11, 12, 13, 16, 19, 22, 23,
Okay.
26, 27, 29, 30, 31, 33, 34, and 35.
And a counsel appearing for respondents 6, 7, 8, 10, Shimanimo has submitted that the counter affidavit could not be filed today and has sought for some more time for the same to be filed. How long?
In the course of the day, Your Worship.
And has sought for and has submitted that the counter affidavit may be allowed to be filed in course of the day. The prayer is allowed. The petitioner, on receipt of a copy of the said counter affidavit, is at liberty to file a rejoinder to the same if so advised. The rejoinder may be filed within the next date fix. How long?
2 weeks, Your Worship.
This is matter of 2 weeks.
5.
My lord, the still respondents are yet to file their written arguments.
Yes, Mr. Khan, you were not here last time. Some prayer was made on your behalf.
Lordship, if you just recollect, in fact, we just got the records from the main records. So the only issue was, Lordship, the
That delay period.
and Lordship will recollect that we got stuck, and rightly so that Lordship had asked us that what is the exact date of the hours. So from the records, Lordship, we have been able to trace. So once that becomes very clear, Lordship, then so if need be, Lordship, it's very bulky record, or maybe we can give the record to the court.
If it is a bulky record, but then you have to
If you file an
you have to
affidavit,
flag it accordingly or point out.
we'll mark it and give it to the court. So we were just struggling with it, Lordship. Should we file an affidavit because it's unnecessary? Court may have to go through all the papers to find out. So that relevant part we can mark it, and we can give it to the court.
Okay. But would see in that case, the petitioner would they be privy to such?
If they want to produce the record, they can
Because
also.
in that case, if you are bringing, perhaps you bring something new at this point of time, or substantiating your argument,
Lordship.
then they would,
Yes,
they
Lordship.
have
Lordship
to
is correct.
they have to respond to that.
We'll bring it on.
Then what you can do, Mr. Khan, you file an affidavit.
Affidavit.
File an additional affidavit. Bring on record those.
Only that part.
Bring yes, on record
And then
those.
we give
Those
them
particular records that you want to, place before the court, only the relevant portion, and then let him file a respond to that.
Only his lordship, because we may take time because the affidavit has to be signed with the DC William Nagar. So all giving that slightly time.
DC what?
The records are here and the DC is there, my
DC
lord,
is there.
and the preparation of the affidavit and thereafter, because they have already transmitted the records here. So we
Some
cannot
time may
ask
be given.
2 weeks
Some
time. What is there?
Otherwise, my lord, if my lord permits me to submit, my lord, may I file this affidavit bringing on record by my my own signature without the affidavit?
There's no provision for that. You are not the party. How can you place yourself? Or you want?
No, my lord, only the relevant portion of the document.
That cannot.
It will take 2 weeks. Maybe let him file on this.
I'll give you time, but do it properly.
Yeah. Court is granting us time.
Yeah, well, I'll give you time, but considering even the fact that the matter is, of course, a long pending one.
Otherwise, our written submissions are ready, my lord. So, without those documents,
It's up to you.
No, I think so. We'll bring the affidavit because that has been the contention. I think so we'll bring now because since it's fallen from the court and maybe that could be a bone of contention again, and there should be given an opportunity at least.
Of course, everything has to be transparent.
Absolutely. They should be given an opportunity at least. And we'll also give an opportunity. If the records are here, we can go through it. Affidavit and opportunity.
Mr. K. Khan, Leonard AG, as appearing for the state respondent, has submitted that the state would like to place on record certain portion of the records relevant to the issue in hand, for which the extract of such from the record may be allowed to be filed by way of an affidavit. It may be pointed out that this matter has already been heard substantially, but for just determination of the issue in hand and the petitioner not objecting to the same, the prayer is allowed. It is made clear that such affidavit be filed definitely on the next date fix, failing which matter will proceed in its usual course.
Absolutely.
As prayed for, this matter took 2 weeks.
Lordship will require the records, even we can produce it, give it to the court also.
That it will be
in case if the court.
But if you see, once you have brought it by way of an affidavit, then the record will not be required.
Item number 7.
This matter pertains to pensionary benefits, Lordship. Lordship, I am seeking an accommodation, Lordship, today due to inability of Mr. K. Paul, Lordship. He is the arguing counsel.
Where's Mr. Paul?
Lord, he is out of station, my lord.
Mention is made on behalf of the Leonard Senior Counsel who is conducting the matter, seeking accommodation on the ground of the said counsel being indisposed, said senior counsel being indisposed. On prayer made, the same is allowed. This is matter to 1 week. We'll proceed with the hearing.
Lordship.
We'll proceed with the hearing.
Actually, I prepared it, Lordship. I'm ready for my part.
All the parties are ready.
So far, state is concerned, Lordship. I'm here. I'm ready. Private respondent, I don't think.
Oh, yes. So you're ready? We'll take it up.
I don't have any instruction.
What instruction? Are you appearing for the respondent?
I don't know. Respondent number 7.
Then?
Actually, private respondent actually just state is defending because the same party, but they filed the affidavit also same. The respondent number 7 filed the affidavit. The content of the affidavit filed by the state respondent and the private respondent are the same. The statement are same. Of course, however, senior may have to say something.
That submission is absolutely incorrect, Your Lordship. You should not mislead, Your Lordship.
No, I'm not misleading, but I've gone through the affidavit filed by the parties.
Please. In the writ petition initially filed, the private respondent has not been read as a private respondent. Later on, they came by and filed an application for implement, Your Lordship. Okay. So where is the question of the state defending the private respondent?
What is the subject matter?
Subject matter
is the so-called alleged custodial debt, Your Lordship, which in fact it is not, Your Lordship.
No, Lordship. I will substantiate, Lordship.
What happened, Your Lordship? Because of the disputed question of facts. No. Involved, Your Lordship, this court, Your Lordship, directed an inquiry to be conducted by the learned district judge. That has been conducted, and the report of the inquiry is before, Your Lordship. That I'll point out, Your Lordship, that there is no.
Your Lordship, if there is anything, I even me also, I will come to all this, Lordship.
Since he is not ready, Your Lordship, then it's up.
Maybe short time may be given, Lord, because short time, maybe 1 week after, or because it's has been pending since 2018, Lordship.
I should not say, my friend should not make that kind of submission, Your Lordship. In fact, they also ask for time, Your Lordship. They should not.
No. There's nothing wrong because because the petitioner will have a bad impression on us because.
Anyway, we'll take it up in due course. Mention is made on behalf of the learned conducting counsel for the respondent number 7, who is said to be indisposed and could not appear for the court today. As such, accommodation is sought for today. On the prayer being allowed, this matter is now posted to the next date. List is here after 2 weeks.
That's blessed, Lordship.
Item number 13.
Please, Lordship. Lordship, this is that MAC appeal which Lordship has already heard in part. So I had finished my submissions largely. My friend had started. I believe he has a few more additional submissions.
In fact, I have filed my written argument also on the last day.
Okay.
Both parties. So I'll just read out my written argument. It will take hardly 10 minutes here also. Otherwise, orally I have already done.
Or argument is already
done from both parties. So I'll just read out 10 minutes. It will take my written argument.
You've got a copy of his. Have you also given your copy?
We have already received.
You are appearing for all the respondents?
For all the respondent number 1 in all the MSC appeals.
Lordship, this is that matter where Lordship may recall number 2. There was a question of substitution.
Okay. That the owner of the.
Yes, my lord. Yes, my lord.
Okay, who has now disclaimed the ownership?
Yes, my lord. So that was number 2. Number 3, my lord, Mr. Ayub Khan had appeared at some point, but he claims to be a bystander.
Okay. Where's Mr. Khan?
But he has no role in this because he's a bystander. He was a bystander.
But you have arraigned him as a party?
Because he was there in the claim petition. He was arraigned as a party. And frankly, I'm not sure why. So.
Now what do we do if he's not here?
Because he has, with all due respect, my lord, he has nothing to contribute in this matter.
That is beside the point.
True, my lord.
You have made him party. he is he has his right to be heard.
True, my lord, but
even on the last date, Lordship, when I call him up, the matter is going to be taken up. You please send your junior also. He instead told me that why my presence is required. So, Lordship.
No, that is what you say outside court. Unless you want to make that statement at the bar, then the court will take note of it.
But the Lordship, appeal also has been filed by the insurance company only. So the liability also has been.
It's not a question of contributory negligence.
No, my lord.
He is appearing for, Mr. Khan is appearing for an insurance company.
No, my lord. No, my lord. If Lordship recalls, the accident had taken place. It was a bus. Now, Mr. Khan's contention is that he tried to assist after the accident had occurred, and he was misidentified as an owner of the bus, and he was impleaded wrongly.
That should have been settled at the tribunal level.
It should have been. He should have got himself deleted as a party, but that did not happen. So because he was a party in the lower court, I was required to make him a party here.
He has filed his WS
in the lower court. Yes, my lord.
Then why would he file his WS if
to
he's
state
not?
That he has no connection in the matter. That's the limited participation that he did.
But without his presence, I cannot hear this matter.
Lordship has been dragging for
so
long.
True, but we cannot see, Mr. Singh, you may say so, but we cannot bypass the norms.
I can contact him also after other matters.
If Lordship allows, Lordship, if it is possible to hear the parties present today and post it for another date for submissions to be made by respondent number 3, if any. On that day, if he appears here and makes submissions, well and good, because as Mr. Singh has said, this is the third or fourth occasion we are trying to get this matter heard. So we can be heard. If Mr. Khan has something to add to the case, which I'm sure he does not, then he can do so on the next date, my lord.
And Lordship, moreover, he has not filed his written argument also. Both of us have filed. So it seems that he has not found it necessary to file his written argument also.
He should say
so.
No, he should say so.
That's right. That's true. That's true.
Now
we may be heard, my lord. Another date can be fixed.
Without a specific, submission made, how can this court assume that he is not interested, or either he is interested, or he is not part of the process at all?
So, Lordship, since learned advocate for the
I think Mr.
Jindal, I will just read out only 10 minutes.
We'll hear the matter in the presence of all the parties.
Because I have already supplied to him my written argument. So I am to just read out only. I have already done my verbal submission also. So I am just to read out so that my part will be over. Then if he has any, like, land council.
You're reading out, I will hear it, but he will not hear it. How can he respond?
Or maybe after other matters, His Lordship, I shall contact him.
We'll take it up after 1 week.
Lordship, a small request, my lord. Today's order that Lordship will pass may kindly reflect Lordship's desire that respondent number 3 may also be present.
That I'll do.
So that he's present.
The appellant is present. Respondent number 1. You are number 1, Mr. Singh?
Yes, Lordship. So I'm number 1, respondent number 1 and all that.
Respondent number 1 is also present. This matter is fixed today only for the concluding part of the argument to be made by the parties. However, it is noticed that the respondent number 3 is not represented today, and as such, is it a he or she?
It's a she even is called.
She and he. He's representing for driver also.
And as such,
number. He's only for number 3. Number 4 has got ex parte.
And as such, and as such, she may not be in a position to counter the argument raised by the parties. It is also noticed that the respondent number 3 has failed to appear for this court on certain other occasion without comments on the conduct of the respondent 3. This court would deem it fit and proper for the matter to be heard in the presence of all the parties. Accordingly, this matter is now posted to be heard on the next date fix. It is, however, made clear that in the event the respondent 3 fail to appear, the matter shall be heard in her absence. That's it.
That's all. Obliged.
Yes, this matter to all.
Obliged.
Item number 17.
Here we're supposed to file written submission, Lordship, so I pray time on behalf of Mr. A. Khan, Lordship.
Lordship, my written argument is ready, Lordship.
Matter was already heard. Fees for filing of written submission by the parties.
Only under quantum and the that in interest aspect.
Only on
Bullet points, Lordship.
delay. So I'll file my
Ms. P. Varchadi, learned counsel for the respondent number 1, has submitted that the written argument on behalf of the respondent is filed today. Mr. Sheikh, you are in this case?
I am appearing on behalf of Mr. A. Khan, Lordship.
The learned counsel for the appellant is, however, absent, but mention has been made on his behalf by Mr. S. A. Sheikh, learned counsel, who has submitted that he is instructed by the said counsel that accommodation may be allowed to the appellant to pursue this matter. Be that as it may, since the written argument by the respondent 1 has already been filed, the appellant is allowed to file his written argument as was directed by this court in its previous order dated 23/3/2023. As prayed for, this is matter after 2 weeks.
Item number 20.
How long will it take, Mr. Yubin?
My lord, from my side, I think I'll take only 10 minutes, my lord, in this case.
Because if it takes longer, I'll take up Mr. Sangrisu's matter first.
This will take 10 minutes only, my lord, subject to...
I may not take. I may not take even 5 minutes or so.
There's just 2 questions of law that I wanted to point out, my lord.
You are here, Mr. Sangrisu? Oh.
Yes. Only 2 questions of law, my lord. Number one question is that once the magistrate has passed an...
Have you...
my lord.
This matter is part heard or?
No, this is not a part heard, my lord. It's coming in the hearing.
Then you start from the beginning.
Yes, my lord. So, my lord, 2 questions that I wanted to campus is, number 1 is that once an order has been passed, can the criminal court have the power to recall or review its own order? That is one of the questions. Second is, my lord, whether the principle of res judicata will also lie in the criminal cases, my lord. If these two are answered in positive, my lord, then my case, then I can rest my case, my lord, in my favor, my lord. What had happened, my lord? These are the two questions. Now, the very brief facts is this, my lord. There was an FIR, my lord. There was an FIR filed by the private respondents, which senior counsel, Mr. Sangreso, is representing, my lord. They filed the FIR in the representative of a student organizations, my lord, the NGOs, my lord. What was the allegation in the FIR is, the allegation in the FIR is that there was a siphoning or mismanagement of funds that was meant for development of a park that is in Amlaram site, my lord. And this project was, the scheme was given to the forest department, my lord, to implement the scheme of development of the park. I was, at that relevant point of time, I'm the accused person, my lord. I was serving as the chief conservator of forest. Now, being the chief conservator of forest, I was given that responsibility, my lord. And the funds were released. Now, what did I do is that because the funds is not my personal, so I had to open an account in the name of the chief conservator of forest, not in the name of the individual person, my lord. So I did so because that fund needs, it's just a special scheme, so I cannot mix up the funds here and there. So I opened the account for that particular, the specific purposes, and I have given the responsibility for implementing at the ground level to the DFO. The project was implemented. Somehow the NGOs, out of misunderstanding or misconception, they file an FIR saying that they have got some reports from the AG, Accountant General, that there's some mismatched or of the accounts. So on the basis of that, they took it to a level that they're saying that, oh, there was a mismanagement of fund by me. So accordingly, they file an FIR. Investigation was proceeded. Investigation, I was made an accused. Then in the process of the investigation, they said, the private respondents, they say that we realized that we were at fault, we were at wrong, because there was no such mismanagement and it was our misconception. Therefore, they filed an applications before the judge, my lord, at that relevant point of time. The judge gave time to the prosecutor to respond to the applications filed by the complainant. They say that you respond to this because now the complainant wants to withdraw. They're saying that it's by mistake or misconception that they have filed an FIR, so they wanted to withdraw now. So you respond. They did not, the prosecutor, the IO did not come forward to respond. Accordingly, the learned court discharged me from the liability of this case. Finished there, discharged, already done. Now, after so many years, my lord.
That is 227.
Yes. In the spirit of 227, my lord. In the spirit of 227, discharge me from the liabilities. And I will say...
It was proceeding in, before which court?
It was, during those days, it was not separated, my lord, but the district,
As ADC?
As ADC, my lord, yes. But holding the same power
Yes,
of the...
That is under the rules, yes.
No, 21. So, my lord, I will just take to that discharge applications filed by page 21. Oh, this is the order, my lord, page 21.
Yes.
This is the order passed by then the learned additional district magistrate, my lord. It says that this court's order dated 1st of December 2011 refers, the investigating agency has not given any report even after a lapse of given 10 days time. According to the argument of the learned APP on 01/12/2011, that according to the papers filed by the petitioners, they had indicated a Supreme Court ruling which is binding. Also, the parties have shown that they are no longer interested as per the petition. That the prosecution has no say in this. According to the petition dated 21st09/2011 of the JYF, one of the members of the Joint Committee complainant, the Central Executive Committee satisfied that allegation was totally false and misleading. This Central Executive Committee of JYF decided to withdraw the FIR complaint. According to the petition dated 26/09/2011 of the WJSW, one of the members of the Joint Action Committee complainant, the Central Executive Committee satisfied that allegation was totally false and misleading. This Central Executive Committee of WJSU, AMLA-REM, decided to withdraw the FIR complaint. Upon examining the CR and the materials on record, and upon considering all the facts and circumstances of this case, and on due application of my mind, I am of the opinion that since as per Supreme Court ruling, even a non-compoundable section can be made compoundable in certain circumstances. In this case, in the interest of the parties and the society, it can be compoundable, and since the parties are no longer interested to peruse with the case, it would be a waste of time and effort to carry on with the case. Therefore, this case has been closed. Also, since both the WJS and JYF, who are the complainant, have submitted a withdrawal petition, the case against the accused can be dropped. Therefore, I have no hesitation to order the proceedings of this case against the accused be closed and drop and discharge the accused from all liabilities of this instant case. So, my lord, this is rightly or wrongly, this is a judicial order. This order, my lord, this order was never put to challenge, my lord. This order has attained its finality, my lord. This order was never challenged, my lord. But then what was happening under is, my lord, it seems that the investigation was going on in spite of this order discharging, my lord. And in the same FIR, my lord. And they have submitted the charge sheet, my lord. The charge sheet, page 22, my lord. This is the charge sheet that they have submitted. And the charge sheet, this was submitted on 21st/06/2016, my lord. That is after 4 or 5 years, my lord. 2011, December 2011 is the order where the learned court has discharged me.
Yes.
And the charge sheet in the same case, my lord, was filed in June 2016, my lord. And very interestingly, I would like to point out, my lord, this pertains to this pertains to the same Juwai case, my lord. Or same case, the same FIR, my lord.
Yes.
So now, my lord, and the court should not have at all in the first place, my lord, accepted the charge sheet, my lord. Because by accepting this charge sheet, my lord, it is doing something which the law does not permit it to do, my lord. When you cannot do directly, you cannot do indirectly also, my lord. Accepting charge sheet means what? Accepting charge means you are setting aside this order, which has discharged me, my lord. Section 326 of the Code of Criminal Procedure is very clear, my lord. 326 of the Code of Criminal Procedure my book is there now. I've marked that time. 326. Just show me. 326. No, not 326. Just give me a second, my lord. Where's my book that I marked that time? No, you didn't mark. See, just 3. I think I have met a wrong quoting of this. Give me that page, man. CRPC which I put it. I have not. Huh?
What do you mean to say?
No, my lord, there's a provision I've just slipped off my mind. There's a provision which says that the criminal court has no power to modify 362, my lord. I'm sorry, 362, my lord. Yes, my lord. 362, my lord. Thank you. 362, yes. 362, my lord, of the CRPC. Safe as otherwise, my lord, provided by this court or by any law for the time being in force, no court, when it has signed its judgment or final order disposing of a case, shall alter or review the same except to correct a clerical or arithmetical error, my lord. So this provision has clearly barred the criminal courts from modifying or from recalling its order, my lord, except if there is any clerical errors or arithmetical errors, then they are permitted to do so. Now, my lord, by accepting this charge sheet, my lord, the court has erred in law, my lord. Now, my lord, this was pointed out because the notice was issued to me, someone was issued to me, I've entered my appearance, and I brought this fact to the notice of the court, my lord. But the court did not consider this aspect of the matter and went on to say that I found there is a prima facie case against the accused person. Therefore, I will proceed for framing of the charge. We're not supposed to go to that extent also because, number one, it is proceeding in the premise of the illegality, my lord, which is not permissible in law, my lord. Therefore, my lord, the impugned order under challenge before my lord is at page 80, my lord. This is the impugned order under challenged. This was passed this was heard in detail, and I have given my submissions, my lord, where I have clearly said that I have already been discharged by this honorable court itself, my lord. My lord, in this context, I would like to rely, my lord, in the judgment of the Supreme Court, my lord, passed in 2004, 7 SCC 338, my lord. 2004, 7 SCC 338. In this case, my lord, what had happened is there was a complaint and the court has already issued a process. In this case, in the case of Adalat Prasad, my lord. Now, the accused person files a case before the same court which issued the process, and the court recalled that process, my lord, and then recalled the process by relying on a case of Matthews, my lord. And in this case, the Matthew was differentiated in this case, my lord, in the Adalat Prasad case, and said in paragraph 16, my lord. In the paragraph 16, what did the Honorable Supreme Court say, my lord? It says at paragraph 16, therefore, in our opinion, the observation of this court in the case of Matthew, that for recalling an erroneous order of issuance of process, no specific provision of law is required, would run counter to the scheme of the court, which has not provided for review and prohibits interference at interlocutory stages. Therefore, we are of the opinion that the view of this court in Matthew's case, that no specific provision is required for recalling an erroneous order amounting to one without jurisdiction, does not lay the correct law, my lord. which means, my lord, you cannot recall once you have passed the process. You cannot at any cost, my lord.
This is by a larger bench.
Matthew's court was given to a larger bench, but my lord, it did not come to a conclusion. Why? Because then the matter became infructuous, my lord. Then the matter became infructuous, my lord. So now, my lord, the second question that comes to our mind is that, my lord, now, my lord, I've shown that order of 2011, June 2011, December 2011, has attained its finality. Now, if the order has attained its finality and no challenge was put to that order, then will the principle of res judicata apply? Because it's between the same complaint, the same accused person, over the same subject matter. It will, my lord, because in a case of my lord, in the case of Bhagat, I've given the citations, my lord. In the case of Bhagat Ram, that is reported in 1972, 2 SCC 466. Show me that. This is the Bhagat's paragraph 13, my lord, may come directly to paragraph 13, not to see. No. I can share. So, my lord, paragraph 13, it's a small paragraph, I'll read very quickly, my lord. Paragraph 13, in view of the fact that the state appeal against the acquittal of Bhagat Ram for offences under section 120B, 218, 347 and 389 IPC had been dismissed by the division bench, it was, in our opinion, not permissible for the third judge to reopen the matter and convict Bhagat Ram for offences under section 347 so and so. The matter had been referred under section 429 of the Code of Criminal Procedure to Jagat Narayan Justice, because there was a difference of opinion between Tyagi Justice and a Ludha Justice regarding the correctness of the acquittal of Bhagat Ram for offences under section 161 IPC and section 51 and A of the Prevention of Corruption Act. Jagat Narayan Justice could go only in these aspects of the matter and arrive at his conclusion. The present was not a case wherein the entire matter relating to the acquittal or conviction of Bhagat Ram had been left open because of the differences of opinion between two judges. Had there been the provision, the whole case relating to Bhagat Ram could legitimately be considered by Jagat Narayan Justice, and he could have formed his own view of the matter regarding the correctness of the order of acquittal made by the trial court in respect of Bhagat Ram. On the contrary, as mentioned earlier, an express order had been made by the division bench upholding the acquittal of Bhagat Ram for offences under section 120B and so, and the state appeal in the respective had been dismissed. The above decision of the judge was binding upon Jagat Narayan Justice, and he was error in convicting Bhagat Ram for offences under section so and so, despite the order of the division bench. It was, from here is important, my lord, it was, in our opinion, not within the competence of the learned judge to reopen the matter and pass the above order of conviction in the face of earlier order of the division bench, whereby the order of acquittal of Bhagat Ram made by the trial judge in respect of the same three charges had been affirmed. The order of the division, unless set aside in appeal of this court, was binding and conclusive in all subsequent proceedings between the parties. The principle of res judicata is also applicable to criminal proceedings, and it is not permissible in the subsequent stage of the same proceedings or in the same other proceedings to convict a person for an offence in respect of which an order for acquittal has already been recorded. The plea of authorised acquit as a bar to prosecution embodied in section 4043 of the Code of Criminal Procedure is banned upon the above wholesome principle, my lord. So, my lord, it is very clear, my lord, once a division bench convicts, upholds the convictions, another bench cannot reopen it until and unless that challenge, that order of conviction has been set aside, because then it becomes a binding. So the principle of res judicata as in the civil cases, are also applicable in the criminal cases, my lord. Now, the second case that I will not read, but I'll just give the citation, my lord. It is the state of Rajasthan versus Tarachand Jain, my lord, reported in 1974, 3 SEC 72, my lord. This paragraph 13 again, my lord. This paragraph 13, my lord, again went. So the principle here also the same thing, my lord, about the principle of res judicata, my lord. So, my lord, having said this, my lord, the order, I would like to reiterate myself, my lord, the order passed by the learned court, and that order was passed by a court having a competent jurisdiction, my lord. Rightly or wrongly, it must have been passed, my lord, but then it has attained its finality, my lord. Now, after 6 years, you cannot just go and file a charge sheet, and the court cannot accept that charge sheet, my lord. And there was no application whatsoever. Forget about recalling, my lord, that they are barred by law also doing. They have not even went. So, my lord, another disturbing aspect that comes to my mind, my lord, is that it's the judiciary propriety at risk. Because once a judicial order, my lord, a highest judicial officer of the district, my lord, district and session judge, my lord, passes an order that I, rightly or wrongly, I discharge this particular man, can the police go ahead, sitting at the nose of the judicial's order, and go for the further investigation, says that, oh, I have found a prima facie case against him? They are doubting at the integrity of the learned judge, my lord. This submission, my lord, I leave it up to my lord, whatever actions or whatever so moto that needs to be taken against the concerned IO, my lord, for deliberately disobeying the court's judicial order, my lord. That I raise my case, my lord.
Before the case is against, may submit my proposal, he can give a comment.
Yes.
Since I'm complaining.
Yes.
My lord, I was complained, disputed. We received information from the authorities. On that basis, we filed the FIR. They registered the FIR. Subsequently, no action was taken against the accused person. Therefore, we even filed a PIR to what the then Guwahati High Court. And then Guwahati High Court is available to page number 16 of the petition. So, page number 19.
You are respondent?
Madam. This is respondent number 5 and 6. 5 and 6. The complaint.
Yes.
Now the case was registered and investigation started, and even the relevant TSP had concluded the investigation, prepared the report, perhaps mentioning that there is no case made out by it. That stage, my lord, the PIR also took up the final hearing, and all the parties were heard. And the Guwahati High Court passed an order, page number 19, or appendix page number.
Yes.
Short of copy, maybe. The issue raised in this topic of PIL rises out of the implementation of a Sinai Park project on the Indo-Bangladesh border. The project was initiated by the Border Development Department of the Government. The length of the project was only donated by the villagers with the expectation that development of the area more generating employment. The central government is sanctioned persons called Federation. The basis of the FIR there was to report of the Controller or Auditor General for the entity According to petitioner, the state government was not taking appropriate action against the principal chief to conserve the forest territory in the project on the midway. Direction was sought for an expeditious independent investigation and revocation of the promotion granted to the respondent. Respondent was the accused person, the present petitioner. The matter was considered from time to time, and finally, on such, it was noted that investigation had been completed by the deputy superintendent of the CIT, to whom the investigation was transferred. Accordingly, direction was issued to the Board of Employment Department of the central government to consider revival of the project, which had been stopped midway on account of the elections and informed this court about the decision taken, and the state government was directed to take action on the report submitted by the investigating officer in accordance with law. We have heard the learned counsel for the petitioner, learned counsel for the central government, learned counsel for the state government of Meghalaya, and the learned counsel for the respondent. The stand of the government is that it is not in agreement with the report of the investigating officer. So perhaps, my lord, the state was disagreeing with the content of the report prepared by the TSP for closing. Learned counsel for the central government states that no decision has so far been taken in view of the in pursuance of the order of this court for revival of the project. He, however, states that decision in accordance in pursuance of the order of this court, since such will be taken within 1 month from the date. Learned counsel for the petitioner states that since investigation is complete, the report of the investigation officer has to be considered in accordance with law by the concerned magistrate, notwithstanding the opinion of the state government. In view of the fact that the report of the investigation officer is to be considered by the concerned court, we refrain from making observation on merit, and investigation officer may submit a report to the concerned order. The concerned court may decide the matter in accordance with law. After this, my lord, we came to know that, my lord, the allegation was not, there is no petition. Therefore, we filed an application before the trial court for withdrawal. That application is available in, my lord, in the same petition, page number 8.
Which number?
Page number 8. After we should be about the additional, it did say the additional, but the petition bring on record.
Page number 8 of the petition.
It's not separate application. Separate application.
That is, I filed on 13th January after leave of the court, my lord. That's a separate petition, my lord.
By way of an affidavit?
My lord.
Serve a copy.
Separate petition?
My lord,
it's
yes.
Not here.
Just let me assist, my lord. It is.
You give us this copy. We'll go through.
No, not this file. Show me the other file.
Oh, this one.
Oh,
It's a miscase.
yes, my lord.
Yes. Page number 8, my lord, we see page number 8.
We have not been.
You have not.
No. Huh? We think that's just a very small application. Senior can read here.
Except he has served in the office. The office yet to give the litigation.
No.
It would not be allowed to 5 years. That is the practice. In any case, my lord,
No, Mr. Shulai, you have any submission to bid?
No, your lordship, I'll just go through for a while.
Fine. Please go ahead. So, this one.
I will take relevant para 4 and 5, it is mentioned.
Yes.
It says the Central Executive Committee of the Sanskrit complainant found upon verification from the branch manager of Canada Bank, such insurance was found that the account is government's account as CCA and not in his personal account as PCMR. So initially, complainant had the impression that he had opened his own account, personal account, to misapprove. When we verified, it was the account of the department, separate account under the department. And another reason is when on the next page 5, the PAC of the Meghalaya Assembly also found that the mistake is because of the incorrect information furnished to the Accountant General and directed the government to verify as to who has sent the incorrect statement to the Accountant General. But no information is sent by government. It was found that it was only version of the Accountant General without any verification. The form that has been known to the Central Executive Committee on a Sunset. In the above circumstances, the Executive Committee of the Sunset decided to withdraw the FIR complaint filed against the accused person. It was found to be in the best interest of the previous members of the unit, and thereafter these recent Central Executive members will not proceed with the essay application. So right over, my lord, this application was put up. Notice was given to the prosecution also. It was heard. Opportunity was granted to the prosecution to give a reply. At that moment, prosecution could have come out and said that this application cannot be entertained. Involving is a serious allegation of misappropriation, corruption matters, it affects public interest, so it is a full test trial. It should have come in, it didn't come. After giving that opportunity, trial court has applied its mind and closed the account, dropped the proceeding and discharged the accused person. Now, if they are agreed with this, the law is very clear, it is an applicable order, they should have preferred agreement within 6 months. They don't. Rather, they continue to proceed for investigation, and file the charge sheet after 6 years. And the trial court has accepted that one. Now, the consequences of the proposition of the prosecution is here, my lord. We are here to assist the court, my lord. My lord, here I'm not only representing the principle number 6, but also to assist the court that what would be the consequences of the action taken by the prosecution if this is allowed to continue. Not only this case, well, all the deserving cases which were closed, discharged by the competent court. Now, the prosecution will wake up after 1, 2, 3 years, 10 years, and file a strong charge sheets, and criminal trial will launch it. This is a very serious effect on the society in the criminal jurisprudence. Therefore, my first submission is that once that decision was taken, and Section 227 is very clear, if the judge, after hearing both the parties, found that there is no sufficient ground. So according to the trial court at that point, 2011, there was no sufficient ground. So he applied his mind. They could have, prosecution could have challenged that part. Allegation will be very serious. It affects public interest. To protect the public interest, the prosecutor, my lord, should resort to the rule of law, the procedure. My lord, but over and above the order passed by trial court, they proceed investigation. This is unknown. This is unknown to the criminal proceedings. If the trial court committed an error, rectify it before this order will come, come back to the trial court and prosecute the culprit. My lord. Prosecution has no authority to investigate the case which was already closed by the court. But the proceeding was, my lord, the trial court was, my lord, was not, the prosecution was not superior to the trial. The trial court order prevails until it is set aside in the combined area. So this was continued. Therefore, my humble submission is question is, other point my friend has taken as officer of the court. My humble and with profound respect to the learned AG of prosecution, they have committed error. And it is too late for the day for the prosecution to file the charges. At best, if they want, they would try or appeal to revoke this one, taking the plea hearing. But they have no authority to proceed the investigation in a final charge. Number one. Number two, once the case is closed by the court of equivalent jurisdiction, another judge who sits in the same chair cannot reopen, because that amounts to review, and that review power is not given. Therefore, the trial court order appears to be very perverse and illegal, untenable. And the only citation I will cite in another case also, why may not the principle of res judicata is applicable in every manner nature of cases, including criminal cases. Once the issue is debated between the parties before the competent court of jurisdiction, and that subject matter is put to rest, there should be a finality of that adjudication. Nobody should make an attempt to resurface it. That I'll just cite this one in close my submission. 2013 by ACC. 2013 by ACC, page number 252. 252. In relevant para 41 to 44. It's very clear.
Yes.
41. In such circumstances, it would be difficult to accept the submissions of Mr. Dinoco that the High Court has erroneously accepted the plea raised by the LR of the respondent. The claim of the appellant is barred by res judicata. Considering the principle of res judicata, this court in such and such, there is ample authority for the proposition that even an erroneous decision or a provision of law operates as res judicata between the parties. The correctness or otherwise of judicial decision has no bearing upon the question whether or not it operates as res judicata. This court also held that a wrong decision by a court having jurisdiction in as much as binding between the parties has a right, one, and it was superseded only by appeals to higher tribunals or other procedure like review, which that law provides. In view of the aforesaid enunciation of the law by this court, it would appear that even if the judgment dated sunset rendered by the High Court in sunset and dismissal of in limit of the SLP sunset arising from the aforesaid judgment is considered to be erroneous in view of the judgment in Selangam case, the matter regarded the locus of standing of the sunset of the legal history. Respondent number 10, to proceed with the mining lease application cannot be permitted to be reopened at this stage since it has become final in the parties. Even though, strictly speaking, res judicata may not be applicable to the proceedings before the central government, the High Court, in exercise of its power under 226, was certainly entitled to take into consideration the previous history of the litigation in the parties to decline the plea to the appellant. Mainly because the High Court has used the expression that the claim of the appellant is barred by res judicata does not necessarily result in notifying the conclusion, which in fact is based on the constitution of equity and justice. Given the history of litigation between the parties, which commenced in sunset, the High Court was justified in finally giving a pointers to the same. The subsequent interpretation of the rule sunset by this court that it would only prospective operation in Selangam case would not have the effect of reopening the matter which was considered between the parties. In our opinion, if the parties are allowed to re-agitate issues which have been decided by the court of competent jurisdiction on a subsequent change in the law, then all the earlier litigation relevant thereto would always remain in a state of efflux. In such circumstances, every time if the statute of provision relief is declared otherwise, it would have the result of reopening of the decided matters within the period of limitation according to the date of such a decision. In this case, not only the High Court had rejected the objection of the appellant to the substitution of the legal case of the concerned settlement place, but the SLP from the state judgment also came dismissed. Even though, strictly speaking, dismissal of the SLP would not result in the merger of the judgment of the High Court in the order of this court, the same cannot be seen before irrelevant. The High Court, in our opinion, committed no error in taking the same in consideration the particular facts of the case, but the immediate decision of the High Court was really based on facts of the case. The High Court has came to the conclusion that appellant had accepted the local standing of the legal case of compulsion to pursue the application to mining lease before the central government as well as the High Court. Now here also matter of the locus of the petitioner, legal question. court dismissed the objection and let the proceed. And later one might also be called pass a different order interpreting certain provision about minorities. And taking that advantage, they raise this issue that the person is not, no, his locus is not making it. So we will say no, that issue is already correct. The same thing here also, not the issue here, with the rightly wrongly, the issue was correct by the trial. This cannot be reopened at this stage. So this is my humble submission, not for everyone, but here, lordship, all the scale of justice very firmly. Everyone, including citizens and prosecutions, are standing equal footing. Citizens are not inferior, or prosecutions are not inferior. Both of them are standing equal footing under the criminal jurisprudence, and the procedure provided in the CRPC has to apply equally. Prosecutors do not enjoy inferior position in this case. Any error passed by the court, either agreed by the citizens or the prosecution, required to be corrected with the procedures, CRPC. That should be resolved. Therefore, the subsequent kind of charges and entertainment by the trial is not take effect. Maybe this submission. I'm representing for number 6, so my time is for 5. Something for respondent number 5 here.
Yes, what do you have to say?
Your Worship, my submission. Your Worship, my submissions are in line with my respected senior respondent number 5 or number 6. Your Worship.
Okay. Yes. Yes. Yes, Mr. Shulay.
May it pleases your Lordship. Lordship, going by the order passed by the then Additional District Magistrate, which is at page 21, it appears, your Lordship, that the case was originally registered under section 499 of the Indian Penal Code. Kindly come again to page 21, your Lordship.
Yes.
At page 21, your Lordship, under section 499, Lordship, on top of it, that section is there, your Lordship, 499. So it is a case, original case of 499. Then what happened, your Lordship? It is true, your Lordship, it is true that that case has been disposed of on being, because the informant in that case did not want to proceed with the case, but still, maybe, your Lordship, this order was not communicated. The investigating officer must not be aware of this order, and he carried on the investigation, your Lordship. Then what happened? He filed a charge sheet, your Lordship, not under 499, but under the section 13 of the Prevention of Corruption Act, your Lordship. The charge sheet, your Lordship, is self-explanatory, your Lordship. Then what happened, your Lordship? As they have submitted both of they file an application bringing into the notice of the landed special judge, your Lordship, regarding the dropping of the case, your Lordship. And then the landed session judge, by the order dated 28/10/2022, that is, which is at page 21, your Lordship. Page 21 of the criminal petition, your Lordship.
The miscase, you mean?
No, your Lordship, in the criminal criminal revision, your Lordship. Lordship will find
Page 21 is the order.
Order, your Lordship, yes.
Yes.
Order 28/10/2022.
No, no.
Lordship. Lordship, in the this case,
No,
they
your-
file an application for they file an application, your Lordship. That application, your Lordship, for withdrawing. They brought it into the notice of the learned special judge, your Lordship.
That is right. That is in the miscase.
Yes, your Lordship. Lordship, the learned special judge, Your Lordship, did not agree with that, Your Lordship. Kindly come to page 281, Your Lordship. 28/10/2022. So the learned judge by
Page
81, Your Lordship.
81.
81, Your Lordship. This is the order, Your Lordship, refusing the discharge application, Your Lordship.
Yes.
They file an application for discharge. So this is the order refusing the discharge application, Your Lordship. In that, Your Lordship, the learned session judge was of the opinion that there is a prima facie case, so that the case would continue, Your Lordship. Now the only question, Your Lordship, to be considered Your Lordship, even after the closing of the case, Your Lordship, which is a case under 499, whether the investigating officer can make investigation under different section of law and file a charge sheet. If Your Lordship comes to a conclusion, yes, that if the answer is yes, then Your Lordship, the case will proceed. But if Your Lordship comes to the conclusion, no, that the investigating officer is a stump, because in view of the fact that the case has been dropped, then Your Lordship, I have no case.
So that's it.
That is it.
It is a very sad commentary on how matters have proceeded, with, as has been submitted by the parties, with due respect to the officer concerned. Judicial impropriety has occurred. That is one thing.
Yes.
We are very, you see, this court has heard the parties, and it is well settled. You see, well settled. The principle of res judicata in any form would apply in any proceeding. That is always the, you see, that is always that is always the principle of jurisprudence. Yes. What struck this court is as has been submitted, the audacity of the IO, yes, to carry on with the matter, yes, without a proper direction. Yes. And the learned AAG is submitting that the IO may not have been aware of this order is very, very unlikely. You are the prosecution, you are supposed to keep track of your case. That has not been done. And I have heard the parties are passing the orders.
Obliged.
Item number 2.
Mr. Singon, have you concluded, or you are starting, or you are in the midst? I've forgotten.
My lord, I have already started on the last date, my lord.
You were on, yes, you are on the issue of maintainability. So how long will it take?
It takes some time, my lord.
Some time?
Try to finish early, my lord.
Because you have to consider Mr. Vrchaji school duty. That's always the stoic, argument.
A good father, my lord. I used to meet him in the morning when we dropped them, but I'm unable to follow him in the evening. He surpassed me, my lord.
Yes. You are in WBC?
My lord has my affidavit, my lord.
In
a copy of my affidavit that I filed, that is
118 or 217?
217.
Your affidavit dated?
Dated 14th November 2022, my lord.
Yes. November 2022.
My lord.
But you have already.
My lord.
This
my
is
lord,
with regard to the private and public fund.
Yes, my lord. I have already covered on the last occasion what is public fund and what is regimental fund. I have already stated that and also referred to judgment also, my lord, which is already referred here in my affidavit, my lord. In that case, my lord, Honorable Supreme Court has said what is already discussed about the public fund and what is regimental fund. And as far as our case is concerned, my lord, the petitioner, my lord, herein did not produce any document to show that we are receiving funds from the public fund, my lord. We are receiving money from the public fund, my lord. They have not produced any documents as regard to that aspect, my lord. And as far as regimental funds are concerned, my lord, this is the fund of the Jawans, who it is their contributions, and also whenever there is any my lord, these programs are held, some collections are on Army Day and Air Force Day, Navy Day, my lord. Some collections are my lord, yes, my lord, some collections receives on these dates, on Army Day, Air Force Day, and also, my lord, some monies received from fish culture, horticultures. These, my lord, these constitute the regimental fund, my lord. So, my lord, as far as the present case, my lord, the petitioner herein, my lord, did not produce any documents to show that we are receiving any money from the public fund, my lord. Therefore, it cannot be constituted that the school is under pervasive financial control of the union or state, my lord. Now, my next judgment which I have referred regarding in my page number 5 of my affidavit, my lord, that is Sukhdev Singh, where, my lord, I have also referred regarding Life Insurance Corporation and Oil and Natural Gas Commission's employee. Now, my lord, even though they are the employee of these organizations, my lord, but they are not considered to be an employee of the union, because only for the purpose of their employment, my lord, they are considered to be here. If my lord will come to page number 5, my lord, of my affidavit.
Yes.
It says the employees of the statutory bodies have a statutory status and they are entitled to declaration of being in employment when their dismissal or removal is in contraventions of the statutory provisions, my lord. However, these employees are not servant of the union or the state, my lord. So, even these statutory bodies, my lord, their employees are not considered to be an employee of the union or the state. Here, as far as this case is concerned, my lord, the teachers who are the petitioners and the other staff, my lord, working in the school, which is registered under the Societies Act, my lord, they cannot be considered to be an employee under the union or the state, so to implement the 6 CPC or any pay commissions, my lord. And my lord, and I have also referred to the annexure 1 of my affidavit, my lord, wherein I have stated already that the category under which the CBSE has given us affiliation, that has already been changed because the previous affiliation was given wrongly. Now, thereafter, my lord, I have also referred to the case of Lal Singh versus Union, which was passed by this honorable court, wherein, my lord, this court has held that writ petition is not maintainable because the dispute which are involved in that case belonging to the same school, my lord, that is private in nature. So in such circumstances, my lord, the High Court under Article 226 should not exercise any jurisdiction. And thereafter, my lord, I have also referred to the judgment that is Asa Kosa and other, wherein, my lord, I have referred to Army Welfare, Army Public School, my lord. That is at page number 9.
Yes.
Even in this case, my lord, what was held is Army Public School, which was also a society, my lord. The court has held that because the school is not receiving any fund from the union or the state, my lord, that was not considered to be a state under Article 12, and therefore that school was not considered to be state under Article 12. Then, my lord, I have referred on the last occasion regarding the judgment of the Honorable Supreme Court in Union of India and Others versus S.L. Abbas, my lord, at page number 10, wherein, my lord, the Honorable Court, Supreme Court has held who should be transferred where is a matter for the appropriate authority to decide unless the order of transfer is vitiated by mala fide or is made in violation of any statutory provisions. The court cannot interfere with it. Here, my lord, the rule which we are referring here, the rule which is under challenge, my lord, these rules are not formed under Article 309, which I have already, my lord, 309 of our constitution, my lord. The power to frame rules, service rule, my lord, that is provided under Article 309 of the constitution. Now, as far as these rules which is under challenge, my lord, these are purely private in nature, made by the school authorities, and therefore, my lord, we cannot come into any conclusion that there can be a violation of statutory provision because these are not rule framed under Article 309, and therefore, my lord, such rule, even if any violation is there, my lord, that cannot be enforced under Article 226, my lord. And similarly, my lord, I have also referred to the judgment of St. Mary's Education Society, my lord, wherein, my lord, the Honorable Supreme Court in that case, my lord, has held that as far as CBSE bylaws are concerned, my lord, even if such bylaws are violated, that cannot be considered to be a violation of any enforceable rights. That relevant portion I will just read out for refreshing our memories, my lord. Here it says, first, as discussed above, the CBSE itself is not a statutory body, nor the regulations framed by it has any statutory force. Secondly, the mere fact that the board grants recognition to the institutions on certain terms and conditions itself does not confer any enforceable rights on any person as against the committee of management. Now, this is a very recent judgment of 2022, wherein Honorable Supreme Court has held on about a private educational institutions. Herein, my lord, St. Mary's Education Society is a society who is running school, my lord, which is running school. So, but though that school was affiliated to the CBSE, my lord. But Honorable Supreme Court says, even if there is any violation of bylaws, affiliation bylaws, that cannot be a ground for coming under Article 226 for any violation of their rights, because it does not give any enforceable rights. So similarly, in earlier cases, my lord, I will have to go to those past cases because those are also connected. In those past cases, what has happened is, my lord, the Honorable High Court in the single bench, my lord, when the matter of 6 CPC came, demand of 6 CPC came, my lord, Honorable single judge, my lord, dismissed the case on the ground that that matter is not maintainable because it's a private in nature. It cannot be entertained under Article 226. Thereafter, my lord, the petitioner filed a writ appeal, that is writ appeal number 37 of 2000. that is writ appeal number 35 of 2011.
Yes.
An honorable division bench, my lord, that time has held that because the school is performing public duty, discharging public duty, my lord, they are a state. That was held by the Honorable Supreme Court,
Yes.
The Honorable Division Bench. And the matter ultimately went to the Supreme Court also, my lord,
Yes.
and the matter was dismissed. But what was held by the Honorable Single Judge and by the Division Bench? On what basis the order to grant 6 CPC was given, my lord? If my lord has the copy of writ petition, that is 118, the order is enclosed there, my lord.
Yes.
118.
It is annexed in this petition.
Yes, my lord. WPC 118 of 2017, page number 50, my lord.
50.
My lord, the relevant portion I will just read. I'll try to find out. If my lord will come to page number 38. Yes, my lord. My lord, this is an order of the division bench wherein they have discussed about the order which was passed by this single bench, my lord. That is the last portions. The learned single judge nevertheless observed as follows.
Yes. Yes.
However, before parting with the case, I would like to put on record that so far the instant case is concerned, I find that ARPS is affiliated to CBSE, granting affiliation by CBSE. I would like to put on record that so far the instant case is concerned, I find that the ARPS is affiliated to CBSE.
Yes.
Granting affiliation by CBSE is governed by the CBSE affiliation bylaws. Clause 3, subclause 5 of the said bylaws, amongst others, stipulates that the school in India must pay salaries and admissible allowance to the staff not less than the corresponding categories of employees in the state government school, or as per scales, etc., or as prescribed by the Government of India. In other words, payment of salaries and admissible allowance to the staff of the institutions concerned not less than the corresponding categories of employees in respective state government school, or as per scales, etc., prescribed by the Government of India is a condition precedent for granting affiliation to such institution by CBSE, and therefore it cannot be safely presumed that affiliation to ARPS was granted by CBSE only on promise to implement the said provisions of the bylaws. More so, petitioners were getting the pay and allowance earlier in terms of the recommendations of 5th CPC, which is not denied or controverted by the respondent. This court does hopes and trust that the authority would examine the claim of the petitioners and redress their grievances in as much as on their promise to implement the provision of clause 3, subclause 5 of bylaws, the school was affiliated to CBSE. Paragraph 5. On critical examination of the foregoing paragraph, the learned single judge more than suggested that the condition precedent for affiliation of a school with CBSE in terms of clause 3, subclause 5 of the bylaws of CBSE is payment by the school of salaries and allowance to its staff on par with or not less than the pay scales and allowance paid to the corresponding categories of the employees under the state government or as prescribed by the central government. But it nevertheless refrained from using a writ of mandamus to that effect to the school. No cross appeal is preferred against the aforesaid findings. The first point for consideration, therefore, is whether writ petition is maintainable in the present form. Now, if my lord will come to page number 50, my lord. Yes. For the reasons stated in the foregoing, this writ appeal succeeds. The impugned judgment and order of the learned single judge is hereby set aside. Respondent authorities are directed to implement the pay and allowance in terms of 6 CPC to the teaching and non-teaching staff of the school with effect from 1/1/2006, together with increased dearness allowance with effect from so-and-so, and the arrears payable in connection therewith, and extend the service benefit including retirement benefit at par with the employees of Kendra Vidyalaya Sangathan and Jawaharlal Nehru Vidyalaya, Jawaharlal Navodaya Vidyalaya, with arrears and implement the applicable assured career progression and SDA to them without further delay. The entire exercise of implementation of 6 CPC for the benefit of the appellants shall be carried out by the respondent authorities within a period of 3 months from the date of receipt of this judgment. Now, my lord, if we go through this judgment, my lord, the entire order was passed basing on the provisions which was there in the CBSE bylaws, because CBSE bylaws has provided clause 3(5) of the bylaws provided that if any teacher is if any school is affiliated to the CBSE, teachers should be paid either as per the salaries which has been received by the government teachers in the state, or at par with the central government. Now, because of that, the judgment was delivered saying that you have to implement the 6 CPC because the bylaw says. But this is in the year, this judgment of the Honorable Supreme Court came in the year 2012, 5th September 2012, my lord. Now, this order was passed basing on the CBSE bylaws, because bylaw provided that you should give as per the central pay commissions or as per the salary which has been received by the government teachers in the state, my lord. Now, in the year 2022, my lord, this judgment comes which overrules our previous judgment which has been delivered, wherein the Honorable Supreme Court even dismissed our case, and the Honorable Division Bench here, my lord, who has granted the relief to the petitioner, saying that because the bylaw provides, you have to give it. But as I have already mentioned in this case, my lord, this is St. Mary's Education Society case which has come in the year 2022. In this case, what is the value of CBSE bylaws, and what is CBSE? That has been described, that has already been discussed in this case, wherein it says even if there is any violation of these bylaws, it is open to the CBSE to take appropriate action against the committee of management of the institution for withdrawal of recognition in case it finds that the committee of management has not performed its duty in accordance with affiliation bylaws. Even if suppose there is any violation, it is open for the CBSE to de-recognize us from the CBSE affiliation, my lord. But as stated in paragraph 30, it does not confer any enforceable right on any person as against the committee of management, even if there is any violation of CBSE bylaw. Now, as the Honorable Supreme Court has held, the bylaws of the bylaws which are there, bylaws of the CBSE, my lord, these are not enforceable, because this itself, CBSE itself, is a society registered under the Societies Registration Act, my lord, 1860, and the school affiliated to it is not a creature of the statute and hence not a statutory body. CBSE itself is not a statutory body, and therefore, my lord, any bylaws which has been framed by the CBSE, it is not enforceable. It does not have any statutory force, my lord, because there is a distinction about a statute, about a body which is formed by a statute and.
But you see, Mr. Sinkon, the fact is that the CBSE would have its own bylaws, would have its own rules and regulation.
Right.
And those rules and regulation would be binding on the affiliated bodies.
Right. These are binding.
Not necessarily statutory, power.
Yes.
But they do have that
My
binding.
lord,
That binding nature is there.
right. It is there, my lord. But in case suppose some bylaws are not being followed by the school, what is the consequence? It has been discussed in this case, my lord. In that event, CBSE can take an action, appropriate action to de-recognize the school as a CBSE, affiliated to CBSE. But the bylaws itself will not grant any power, will not give any power to any individual, any rights, my lord, because the bylaw cannot provide, because it is not a statutory body, and therefore, my lord, even if there is any violation of any of the bylaws, my lord, it does not give any enforceable rights to any of the people, my lord,
affected by it.
My lord. That is my point. Now, Honorable Supreme Court, my lord, in the case of, my lord, I have given a copy of this judgment, Canara Bank versus NG Subaraya, Seti and another, my lord. It should be there with WPC 217, if I am not wrong, my lord.
Team 217.
My lord, the judgment which I have given, my lord, that is Canara Bank versus NG Subaraya, Shetty. I gave together with the St. Mary's judgment.
Yes.
If my lord will come to page number 6.
Not reported.
Reportable, my lord. This must have been reported already, my lord.
You should have cited.
Well, I'll give the
you should have given the citation.
Yes, my lord. Page number 6, my lord.
Paragraph 5.
Paragraph 5. This judgment, my lord, I am relying on because, my lord, the petitioner herein, my lord, raised a question that I cannot take up the issue again because that has been already decided by the Honorable Supreme Court in the earlier cases. Therefore, my lord, we will read out this paragraph 5, my lord. Res judicata is thus a doctrine of fundamental importance in our legal system. Though it is stated to belong to the realm of procedural law, being statutorily embodied in Section 11 of the Code of Civil Procedure 1908, however, it is not a mere technical doctrine, but it is fundamental in our legal system that there be an end to all litigation. This being the public policy of Indian law. The obverse side of this doctrine is that when applicable, if it is not given full effect to, an abuse of the process of the court takes place. However, there are certain notable exceptions to the applications of the doctrine. One well-known exception is that the doctrine cannot impart finality to an erroneous decision on the jurisdiction of a court. Likewise, an erroneous judgment on a question of law which sanctions something that is illegal also cannot be allowed to operate as res judicata. Here, if the judgment of the Honorable Supreme Court or the High Court, my lord, if the judgment is erroneous. Now, after the judgment, my lord, which I have relied, that is St. Mary's College, my lord, the point that the CBSE bylaws, what is the value, persuasive value of these bylaws framed by a society, my lord?
Yes.
This point has already been discussed by the Honorable Supreme Court, and it has already pointed out that it cannot give an enforceable right even if there is any violation. The only thing which can be done is the CBSE can take appropriate action against the school to de-recognize them from the CBSE, my lord, from CBSE board. That will be the effect. Otherwise, my lord, this does not give any enforceable rights. Even if there is any violation, they cannot come under Article 226, my lord. And therefore, my lord, as this point of law, my lord, this has been already overruled by the St. Mary's College, my lord. And therefore, and the point of res judicata, my lord, this I have already pointed out, my lord, in this judgment, wherein it has clearly mentioned erroneous judgment, my lord, cannot be allowed. This is one of the exceptions where the court can interfere again, my lord. Now,
but Mr. Sinkon,
yes, my lord.
Okay, let us start from the premise that there was an erroneous decision
my lord,
by any court, which has sought to be, enforced as res judicata.
Yes.
Now you're saying that if it is an erroneous decision of law, it will not stand,
my lord,
even if it is passed by a court,
my lord,
say the High Court or even the Supreme Court. So to that effect, see, what will be who will be the competent authority to decide that issue?
My lord,
on the particular case where the decision has already been made.
Decision has already been
reference
made.
Reference has to be made in some other case,
yes,
perhaps, to the decision that was thought to be or found to be erroneous.
My lord,
there must be some. See,
my lord, there has to be some ground. Yes.
Yeah. So even in your case, if you are saying that you're referring to the Lal Singh case.
Yes, my lord. In Lal Singh case, by this court, my lord, in that case, my lord, by this court has very recently, my lord, has held that writ petition is not maintainable. By this court, my lord.
Single bench or division?
Single bench, my lord. And the matter went to the division bench also, my lord. Thereafter, my lord, the matter was withdrawn.
Withdrawn means
yes,
nothing survives.
Nothing survives. So, my lord, I have also given one written argument. If my lord has a copy of it, my lord, there I have mentioned. Must be here only. If my lord has the copy of the affidavit, it is mentioned there also, my lord. That is 14 November 2022.
Affidavit in 217?
Yes, my lord.
At 14/11/2022.
Yes, my lord. If you come to paragraph 28, my lord. Here, my lord, I have mentioned in what circumstances a court is not bound to follow the decisions of another court, my lord.
Yes.
That is the Salmon's jurisprudence, my lord. Here, there are some exceptions, my lord, which which has been given herein, my lord.
Yes.
Number 1 is a decision ceases to be binding if a statute or a statutory rule inconsistent with its subsequently enacted, or if it is reserved or overruled by a higher court.
Yes.
Yes. So for our case, my lord, the first point itself will cover, because in St. Mary's judgment, my lord, what is the value, persuasive value of the bylaws, CBSE bylaws? Because in those earlier cases, it is on the basis of the CBSE bylaws, what was mentioned there, on the basis of that, my lord, the judgment was delivered. In the very recent judgment, St. Mary's College, my lord, what is the value, persuasive value of those bylaws? That has been already described, my lord.
They have no statutory force.
Yes. So, and the second point is, a precedent is not binding if it was rendered in ignorance of a statute or a rule having the force of a statute, my lord. Now here, that was rendered, my lord, on the basis that the bylaws of the schools, these has some force of law, my lord. This does not have any force of law, my lord, because these are purely privately made, my lord, by the school, and these are not framed under Article 309 of the Constitution of India. Therefore, my lord, this cannot be enforced under Article 226, my lord. And the third point is, my lord, a precedent loses its binding force if the court that decided it overlooked an inconsistent decisions of a higher court.
Yes.
Fourth is, a court is not bound by its own previous decisions that are in conflict with one another, my lord. And the third is, my lord, fifth is, a decision passes sub silentio when the particular point of law involved in the decisions is not perceived by the court or present to its mind. Even if some point of law is, my lord, was not present while passing the order of the passing this judgment, my lord, that judgment is not binding, my lord. Now, my lord, I will come back to WPC 217 of 2017, my lord.
Yes.
Now I will touch the issue of amalgamation, my lord. Now here, my lord, the petitioner has challenged the process of amalgamation, saying that that process is wrong, my lord, and therefore that entire the amalgamation process has to be set aside.
Yes.
Now here, if I take your lordship through the documents which has been enclosed in this petition, my lord, if my lord will come to page number 63,
Yes,
my lord.
Of what?
63 of the writ petition, my lord.
217?
217, yes, my lord.
Yes.
In this page, my lord will see at paragraph 3, my lord. It says, while agreeing in principle, the chairman took the view of all other members present. Unanimously, it was decided that the ARPS society will be amalgamated with ROS for better administration of ARPS Light Corps and bring parity to all schools run under the aegis of Assam Riflemen. Now, this is the first decision which was taken.
You're reading?
My lord, page 63, my lord.
63.
Paragraph 3, my lord. Directions of the chairman.
Oh, yeah.
Heading.
This is B2, isn't it?
Yes, A and clause 2, subclause 2, my lord.
Okay, A3 or A2.
2, my lord.
Yes.
Here it says, while agreeing in principle, the chairman took the views of all members present. Unanimously, it was decided that the ARPS society be amalgamated with ROS for better administration of ARPS Light Corps and bring parity to all schools run under aegis of Assam Rifle. This is the first decision which was taken to amalgamate the ARPS society with the ROS, my lord. Now thereafter, my lord, if my lord will come to page number 65, this is a letter, my lord, given to the Registrar of Societies seeking their permission, my lord. I'll just read this paragraph. The Assam Rifle Public School Society Lightcore was registered under Meghalaya Societies Act 1860. Also 41 schools run by Assam Rifle in various parts of Northeast were registered under Assam Rifle Welfare Education Society on 30th June 2015. For ensuring effective management of the Assam Rifle schools and to provide better and improved education facilities as also to maintain uniformity in administration to the extent possible, a need has been felt to put all Assam Rifle schools including ARPS Light Corps under one umbrella. Therefore, a decision for amalgamation of Assam Rifle Public School Society with Assam Rifle Welfare Education Society was unanimously taken during the ARPS governing body meeting held on 20th September 2016. That one, my lord, I have already read out just recently. Under the chairmanship of Lieutenant General H.J.S. Sachdev, Chairman of ROS governing body. But the petitioner herein, my lord, they were in trying to convince this honorable court that this is not an unanimous decision, not taken by both the.
It was, see, the contention was that it was not as per the provision of the act.
I'm coming to that, my lord. I'm coming, but what I'm saying is pointing out here, my lord, chairman of ROS governing body, he is also there, my lord, and even the ARPS governing body was also there, my lord. Both of them, they have decided and then they have sent a letter to the Registrar of Societies seeking their permission, my lord. No objection certificate for such amalgamation. Now, after seeking such no objection, my lord, at page number 66, no objection was provided by the Registrar of Societies, my lord. Here, if I read out, my lord, page number 66.
Yes.
With reference to your letter on subject cited above, I am to inform you that in pursuance to section 12B of the Meghalaya Societies Registration Act 1983, this office does not have any objection to the amalgamation of Assam Rifle Public School Society bearing registration number so and so with Assam Rifle Welfare Education Society bearing registration number so and so. The assets and liabilities of the Assam Rifle Public School Society shall be the assets and liabilities of the Assam Rifle Welfare Education Society in pursuance to section 12C of the Meghalaya Societies Registration Act 1983 and as decided by the governing body meeting of both societies. As decided by the governing body meeting of both societies held on 20th September 2016 at Conference Hall, Headquarters, DGAR, my lord. This is the no objection certificate, my lord, which was given by the Registrar of Societies for such amalgamation. And after this, my lord, the entire amalgamation process gets completed, my lord. Now, thereafter, my lord, after the entire amalgamation, my lord, is over, decision was taken to make addition in the rule. And that is at page number 72, if my lord will come to page number 72.
Yes.
Paragraph N, my lord. Additions in ROS rules and regulations.
Yes.
Here, the first point is presently no competence tests are being conducted to assess the suitability of principal teachers of ARPS. Suitability competence test for principal and teachers teaching in ARPS will be conducted on an yearly basis. Their further extension, retention in service will depend on the result of the test. Presently, the permanent regular teachers are not being considered for transfer after 3 years of regular service. Transfer of all permanent teachers of ARPS after 3 years of regular service. This was proposed to be added, my lord. Thereafter, my lord, after this, they have sent a letter to the Register of Societies, that is as page number 76, my lord.
Yes.
After this, my lord, they send a letter to the Register of Societies for addition in ROS Rules and Regulation Book, my lord. The ROS Rules and Regulation Book was registered with under the Register of Societies, Meghalaya, Shillong. Copy of the same is held with your office. The ROS governing body meets was held on such and such date. Certain addition to be incorporated in ROS Rules and Regulation were presented before the body, which are as under. So the same changes, the same, my lord, the rule which is I have already read out.
Yes.
This was to be incorporated again in the rule book, my lord. And therefore, my lord, forwarded for your information and inclusion of rules as mentioned in paragraph 3 in ROS Rules and Regulation Book. Thereafter, my lord, the Register of Societies, my lord, gave approval dated 2/5/2017 for addition in the rule book, that is at page number 77. This is the approval which was given for such addition, my lord.
Yes.
It says, with reference to the subject cited above, I am to convey the approval to your association to the proposed addition in Rules and Regulation Book as adopted in the meeting by your governing body on such and such date, subject to your submissions of the resolution with the list of members present with the signature. Thereafter, you are required to file a copy of the alteration addition to this. My lord, this approval was given, and thereafter, my lord, this rule, amended rule, my lord, which was incorporated in the ROS rules, my lord. And thereafter, after this inclusion of the rule, my lord, the amended rule, the ROS became competent to make a transfer order, my lord. And thereafter, my lord, the transfer order in those first cases, my lord, those transfer order were issued, my lord. And my lord, there one of the ground, my lord, why the amalgamation is wrong. If my lord will come to page number 31.
31 of?
31 of the writ petition only, my lord. 217.
Yes.
Here they have referred to a rule that is act, my lord, that for the purpose of better appreciating the provision of law relating to amalgamation of societies, it is relevant to refer to section 12 of the Meghalaya Societies Registration Act 1983, which is extracted below. This is the section 12 of Meghalaya Societies Registration Act 1983, under which, my lord, ROS is formed, my lord.
Yes.
Now, this rule, it says amalgamation of societies. Whenever two or more societies desire to amalgamate, the governing body of each society shall submit the proposal in writing to the members thereof, and such proposal shall be considered in a general meeting of the society convened for the purpose. No such proposal shall have any effect unless it has been delivered or sent by registered post to the members of each of the societies at least 10 days before the date of the meeting of which it will be considered. It has been sent to the registrar before the meeting and he communicates his approval thereto with or without any modification. The proposal with the modifications, if any suggested by the registrar, is agreed to by the 3/4 of the members each of the societies concerned and confirmed by like votes of members at the subsequent general meeting of the amalgamated society. Here it says if there is any need to amalgamate any two societies, my lord, then the governing body of each of the societies shall submit the proposal in writing to the members thereof. They shall submit a proposal to the members. Now here, my lord, the petitioner, my lord, who are challenging this amalgamation process, even if suppose any right has been created by the act, by the Meghalaya Societies Registration Act 1983, this right, if suppose the members has the right that they should be informed. Now if suppose they are not being informed, the members, they have the right to challenge the amalgamation process. It is not for the petitioner, my lord, who do not even have the locus to challenge this amalgamation process, because there is need to be violation of their rights, and right has to be originated from a statute. Now the Meghalaya Societies Registration Act 1983, it gives the right to the members. It says they have to be such proposal in writing to the members thereof. Now the proposal should be sent to the members. It is admitted position that they are the teachers who are working in the said school, my lord. They are not even a members. Now while challenging the amalgamation process, the members, my lord, they are not even been made a party in this entire proceeding, my lord, and therefore they do not have any locus to challenge this amalgamation process.
Yes.
Because it does not create any right.
Yes.
And unless there is any violation of their right, they cannot come and challenge the process of amalgamation, my lord, under Article 226. There has to be violation of the rights, and right has to come from a statute.
Yes.
Now statute does not provide them any rights. The rights are with the members, and they are not the members, my lord. Now, more or less, my lord, I have completed my submission. That first of all, my lord, the amalgamation process will not come into place when deciding the cases relating to the transfer order, my lord. That has got no bearing, because, my lord, that is totally a separate case, because that is only on the they have challenged only the amalgamation process. As far as the transfer matters are concerned, my lord, these matters, my lord, has to be decided on the basis of the grounds which they have taken. Even if suppose we for a second, my lord, we accept that it is maintainable under Article 226 to challenge the order. Even if we accept it to be maintainable, my lord, this has to be seen on the grounds which they have taken in the writ petition, my lord. Challenging those transfer, whether those grounds which they have taken, those are valid as on today, my lord. Now, before we go to see the ground, my lord, at the threshold, my lord, the petition is not maintainable, my lord, because they cannot come under Article 226, because these are purely a contractual in nature, my lord. I have already pointed out, my lord, in the Sebastian P. George, my lord, that is at page number here at page number 27, contract of service. This is signed between the employer and the employee. Teachers also, they are party to this, my lord. Here at paragraph 5 of this contract, my lord, it has been clearly mentioned, the party number 1 will confirm, that is the teachers, my lord, will confirm to all the rules and regulations in force in the school and the school, and shall carry out all such orders and directions as he shall from time to time receive from the managing committee, principal, or any of the authorized member of the staff. Now, if we see, my lord, there has been a clear violation of these terms of this contract, and therefore, my lord, this is purely a private in nature. Entire dispute is purely a private in nature. Now, because the school is a private school, my lord, and as I have pointed out, there is no fund which has been received by the school from the union or the state, my lord. And whatever at only in 1 or 2 occasions, my lord, we have received money from regimental fund, that also for the purpose of not closing down the school, my lord. Otherwise, after implementation of the 6 CPC, my lord, as directed on the last cases, my lord, we had very much financial crunch, and therefore, my lord, so that the school does not get shut down, does not close down, my lord, the money was provided from the regimental fund, so that the school will continue and they can serve the people, my lord. So I rest my submissions, my lord, only if in case I need to reply anything, my lord.
What do we do? Now we are 11.
My friend and Leonard CGC also yet to submit.
1:30 now.
But in the second half, my friend has a problem. May I suggest Monday, my lord? We'll conclude on Monday, my lord.
Tuesday.
Or, my lord, Wednesday, if lordship permits. Wednesday, Tuesday, I have some difficulty. I have that inquiry is going on that Umbroy matter fixed on Tuesday. Because of that. Wednesday, my lord.
Wednesday.
At least as a first item. Huh?
Okay, you will not be free Wednesday. Oh, Wednesday. So he'll not be free on Thursday. And then we go on.
All week over, my lord.
Or Friday, my lord, the next Friday, coming Friday.
Monday, yeah, not free.
I can do.
Monday also it's all right.
Monday I may not be available. Tuesday I was okay actually. But then
Okay, Friday then.
My lord.
Friday would be good. Since my friend has concluded, my lord, only
yes, now
the respondent will give,
and
then I'll give reply.
hardly, I also hardly 10 minutes.
Parties heard Leonard, counsel for the respondent, ERPS. However, the counsel for the other respondents have submitted that this matter may be continued on the next date. As submitted, list this matter on 28 for further hearing.
Your Lordship, your intentions that item number 21, Your Lordship, actually is supposed to call for the second for order. Actually, my learned friend he was asking for filing the affidavit. So I pray that then I pray for at the meantime I may be allowed to just file one additional affidavit to bring on the court.
The matter is not yet called, and you're
actually, Lordship, just actually it was adjourned, but at that
no, adjourned. I said you yourself Lordship. Said wait. The
yes.
matter will be called up.
Yes, Lordship.
And in the meantime, you have jumped the gun.
They said it is reflected mentioned they have not called me by mistake. That's where
look at the court master. She's like a school teacher. She's so stern. Yeah? You make any mistake, she'll not give you any concession. Call up Usman.
Item number 41.
So, now what is your submission?
My submission is that my learned friend, he said he want to file some affidavit to this effect. Then that's why at the meantime, if I may also allow to file just an additional affidavit at the time when he was filing.
On what ground?
Actually, as I submitted, there was this petitioner have filed a complaint against the inquiry officer himself. That saying that he has abuse of process, that all the
inquiry officer or the IO?
Against the IO. Against the IO. So, allegation of the petitioner is that he has all the investigation has done in favor of the private respondent, and to that effect he has filed a complaint to change the IO, in making an allegation that he's not doing that. So that record I just wanted to bring, so it will for the interest of justice. But I'm not changed, but it will be good at least.
He has filed a series of complaints against me because in fact the allegation who nothing survived. That is why the court has rightly dismissed the application, because these are all while discharging their public duties here.
That all things will come at the time of hearing, and moreover, he is the private respondent.
Mr. Sheikh, what do you want to file?
I want to file one affidavit bringing on some relevant facts, Lord Chief.
He is the
Factual aspects.
He is the private respondent,
I'm not
whereby
making any counter affidavit, just factual aspects.
Mr. P.T. Sawal, learned counsel for the petitioner, has submitted that you may be allowed to file
the additional
an additional affidavit bringing on record certain developments which took place after the institution of this petition,
Lordship,
which pertains to the subject matter, or rather the complaint filed by the petitioner herein. Rather, the complaint filed before the competent authority by the petitioner herein. Mr. S.A. Sheikh, learned counsel, you are appearing for all the respondents?
Private respondent 5, 6 and 7, Lordship.
Appearing for
1
the
to 4 is state respondent.
appearing for the respondent 5, 6, 7 and 8 respectively.
5, 6, 7.
5, 6 and 7 respectively, has also submitted that he may be allowed to bring on record certain facts by way of an affidavit.
After 3 weeks, Lordship.
Prayer made, the same is allowed?
3 weeks.
2 weeks.
2 weeks also will do. It's up to you.
3 weeks.
As prayed for, this is matter of the 3 weeks.
Lordship. Much blessed, Lordship.